Act Number 4103, an act to provide an indeterminate sentence and parole for all persons convicted of certain crimes by the courts of the Philippine Islands, to create a board of indeterminate sentence and to provide funds therefor and for other purposes. So, ang Act 4103, amo ni siya ang Philippine law nga gatag sang minimum and maximum prison term instead sang fixed sentence. And also, ginaalaw na din nila ang mga eligible prisoners para ma-release early kung makitaan sila sa good behavior. Hereafter, in imposing a prison sentence for an offense punished by the Revised Penal Code or its amendments, the court shall sentence the accused to an indeterminate sentence, the maximum term of which shall be that which, in view of the attending circumstances, could be properly imposed under the rules of the said code. So, for crimes under the Revised Penal Code, ang court kuno is gatag ni siya sang sentence with a minimum and maximum time. Kung sa din ang longest prison period is naset na di siya correctly based on the case details and following law. And the minimum which shall be within the range of the penalty next lower to that prescribed by the code for the offense. And if the offense is punished by any other law, the court shall sentence the accused to an indeterminate sentence, the maximum term of which shall not exceed the minimum fixed by said law, and the minimum shall not be less than the minimum term prescribed by the same. So, for crimes under the Revised Penal Code, the minimum prison time is ginakuha ni siya from the next lower penalty level. And for crimes under the other special laws, ang court is gatag ni siya sa mga indeterminate sentence, which are the maximum and minimum prison time na dapat is nag-follow ginadi sila sa mga kung anong nakabutang bala sa law. Section 2. This act shall not apply to persons convicted of offenses punished with the death penalty or life imprisonment. To those convicted of treason, conspiracy or proposal to commit treason, to those convicted of misprision of treason, rebellion, sedition, or espionage, to those convicted, to those who are habitual delinquents, to those who have escaped from confinement or evaded sentence. So, ini nga law is hindi na di-covered ang mga priso or ang mga persons nga may kaso sang death or life imprisonment or ang na-sentence bala sang death or life or imprisonment. Ang mga guilty nga mga people sa treason or similar crimes, habitual offenders, and sa mga tao nga nagpriso, nga nagtakas or basta nagwabala sa mga sa prisuan, hindi na di siya cover sang law. To those who having been granted conditional pardon by the chief executive shall have violated the terms thereof, to those whose maximum term of imprisonment does not exceed 1 year, not to those already sentenced by final judgment and at the time of approval of this act, except as provided in section 5 thereof. So, ini nga law is hindi na di covered also ang mga tao nga nag-violate sang ilang conditional pardon, crimes with maximum imprisonment of 1 year or less, and ang mga tao nga already nga na-sentence before the law took effect, except sa na-state diri sa Section 5. Section 3. There is hereby created a Board of Pardons and Parole to be composed of the Secretary of Justice, who shall be its chairman, and 4 members to be appointed by the President, with the consent of the Commission on Appointments, who shall hold office for a term of 6 years provided. So, diri gin-establish na di ang Boards of Pardon and Parole nga ginapangunahan sang Secretary of Justice with 4 members nga na-appoint sang President, and gun-confirm na di siya sang Commission on Appointments serving for 6 years. The 1 member of the board shall be trained sociologist, 1 a clergyman or educators, 1 psychiatrist, unless a trained psychiatrist be employed by the board, and the other member shall be persons qualified for such work by training and experience. At least 1 of the board shall be a woman of the members of the President Board. So, dapat ang board is mayar ni siya sang isa ka sociologist, 1 clergyman or educator, isa ka psychiatrist or na-hired bala as psychiatrist, other qualified members, and at least 1 female member. Two shall be designated by the President to continue until December 30, 1969. In case of any vacancy in the membership of the board, a successor may be appointed to serve only for the unexpired portion of the term of the respective members. So, ang two members nga ni is gina-appoint ni siya sang president para mag-serve until December 30, 1969. And in replacement shall serve only the unexpired part of the term. Section 4. The Board of Pardons and Parole is authorized to adopt such rules and regulations as may be necessary for carrying out its functions and duties. The Board is empowered to call upon any bureau, office, branch, subdivision, agency, connection with the performance of its functions. So, the Board may create necessary rules and call upon any government, office, or agency to help it perform its functions. A majority of all members or instrumentality of the government for such assistance as it may need and shall constitute a quorum, and a majority vote shall be necessary to arrive at a decision. Any dissent from the majority opinion shall be reduced to writing and filed with the records of the proceedings. So, more than half of the members makes a valid meeting. Decisions are made by majority vote, and any disagreement must be written down and kept in records. Each member of the board, including the chairman and the executive officer, shall be entitled to receive as a compensation 50 pesos for each meeting actually attended by him. Notwithstanding the provisions of Section 259 of the revised administrative code, and in addition thereto, reimbursement of actual and necessary traveling expenses incurred in the performance of duties, provided, however, that the board meetings will not be more than 3 times a week. So each member receives 50 pesos per meeting attended plus reimbursement for travel costs, and meetings shall not be held more than 3 times a week. Section 5. It shall be the duty of the Board of Indeterminate Sentence to look into the physical, mental, and moral record of the prisoners who shall be eligible to parole and to determine the proper time of release of such prisoners. Whenever any prisoner shall have served the minimum penalty imposed on him, and it shall appear to the Board of Indeterminate Sentence from the reports of the prisoner, work, and conduct which may be received in accordance. So, the board shall examine the physical, mental, and moral records of prisoners eligible for parole, determine their proper release time, and review their work and behavior reports once they have served their minimum sentence. With the rules and regulations prescribed, and from the study of investigation made by the board itself, that such prisoner is fitted by his training of a release, that there is a reasonable probability that such prisoner will live and remain at liberty without violating the law, and that such release will not be incompatible with the welfare of society. So, following rules to their own checks, the board decides release only if the prisoner is ready, likely to obey the law, and this release will not harm society. Said board release of such prisoner on parole upon such terms and conditions are here in accordance with the rules and regulations adopted hereunder. Authorize the prescribed, and as may be prescribed by the board, the said Board of Indeterminate Sentence shall also examine the records and status of prisoners who shall have been convicted of any offense other than those named in Section 2 thereof. So the board can grant parole based on its rules and conditions, and shall also review the records and status of all prisoners not listed as excluded in Section 2, and have been sentenced for more than 1 year by final judgment prior to the date on which this act shall take effect, and shall make recommendation in all such cases to the Governor General with regard to the parole of such prisoners as they shall deem qualified for parole as herein provided, after they shall have served a period of imprisonment not less than the minimum period for which they might have been sentenced under this act for the same offense. So, for prisoners sentenced to over 1 year before this law took effect, The board shall recommend parole to the Governor General if they have served at least the minimum term set by this law and are found qualified. Every prisoner released from the confinement on parole by virtue of this act shall at such times in such manner as may be required by the conditions of his parole, as may be designated by the said board for such purpose, report personally to such government officials and other parole officers hereafter appointed by the Board of Indeterminate Sentence for a period of surveillance equivalent to the remaining portion of the maximum sentence imposed upon him, or until final release or discharge by the Board of Indeterminate Sentence as herein provided. The official so designated shall keep such records and make such reports and perform such other duties hereunder as may be required by said board. The limits of residence of such paroled prisoner during his parole may be fixed and from time to time changed by the said board in its direction. If during the period of surveillance such paroled prisoner shall show himself to be a law-abiding citizen and shall not violate of any of the laws of the Philippine Islands, the Board of Indeterminate Sentence may issue a final certificate of release in his favor, which shall entitle him for or to final release and discharge. So, every prisoner released on parole under this law must follow the rules and conditions set by the board. They have to report personally to assigned government officials or parole officers at required times and manner, for as long as the remaining part of their maximum sentence or until they are fully released. The officials in charge will keep records and do other tasks as ordered by the board. The board can also set or change the place where the parole is allowed to stay. If during the supervision period the parole behaves as well, obeys the law, and does not commit any crime, for the board will give them a final certificate of release, meaning they are completely free and discharged.